next case to come before the court is In Re LTTT, the second BP and AT. Each party will have up to 15 minutes to present their arguments. I would ask before we start, are you waiting on either of you waiting on anybody else? Okay.
Not that I know of, Your Honor.
Okay, the appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know and I'll be keeping track of the time. The arguments are being recorded, so please keep your voice up in the name behind the podium. You should not use the names of children. You may use initials or terms that are general. The judges have read your briefs and are ready to proceed when you are, and I would ask the appellant, would you like to reserve time?
Thank you, Your Honor. May it please the court. Appellant would like to reserve 5 minutes for rebuttal.
Very well. You may proceed when you're ready.
Thank you, Your Honors. May it please the court. My name is Attorney Wesley Buchanan. I have the privilege of representing Melissa Thomason, who is the appellant and mother in this matter. As indicated, we'll have 5 minutes for rebuttal. At the outset, Melissa will note that this court will review a grant or denial of visitation for an abuse of discretion standard. However, if the trial court makes an error of law, this court is permitted to do a de novo review. So Melissa is the mother of 4 children, which are the subject of this case. Unfortunately, during Melissa's life, CSB became involved through the addiction process, and then eventually, when CSB was involved, they awarded legal custody to Rhonda Gallagher, who is the paternal grandmother in this case. However, the court did not eliminate Melissa's residual parental rights, and one of those residual parental rights is the right to reasonable visitation. Now, the court, and the timeline here is important for the court to note. Melissa had filed her motions in 2020, April of 2020. The court did not have a full and complete hearing until April of 2022. So this process took about 2 years for these motions and the trial, in essence, for visitation, and all the motions that were filed by the various parties to be heard. During that period of time, tragically, and we'd also note that the GAL that was assigned during the CSB intervention was also the GAL, the guardian ad litem, that was assigned to this case as well. So there was some consistency within the guardian ad litem. As far as this case was concerned, the alienation that Melissa can demonstrate was the tragedy that befell one of the children. Tragically, one of the children attempted suicide. And it was uncontroverted through all the testimony that Melissa did not find out until the next day from legal custodian. In addition, the uncontroverted testimony indicated that the legal custodian never communicated with Melissa, the mother. In fact, the testimony in the transcripts indicates that the father was notified the next day. In a day and age where it takes less than 3 seconds to throw a text, as the kids say, to anybody, it is axiomatic that if one of your children suffers a tragedy, information should be passed. So at least as far as Melissa is concerned, the trial court abused its discretion by not indicating those facts and completely discounting Melissa's background. In addition, as cited in the brief, this court, and I will probably mispronounce the last name, it's Smezak v. Tanner, and that was 2012, Ohio 540, which was cited in the brief. This court had indicated that if a parent remedies a situation, then visitation should not be withheld. And that was indicated as far as the mother in that case, that she had supervised visitation due to some allegations. These allegations were much like the allegations that were against Melissa. However, the mother in that case had remedied those allegations, and the court found an abuse of discretion by not increasing mother's visitation and by not permitting overnights and those extended visitations. In addition, as far as the unreasonableness of the court's order, the court completely discounted Melissa's testimony, as indicated by the judgment entry that the court did issue. However, the court did, in the transcripts, had to warn the legal custodian that she had to answer the questions.
After the court in its decision found your client not to be credible, is that fair?
Correct. Correct, and the court did make that finding in its journal entry.
Are you disputing that finding now?
As far as, we have raised that issue in the brief, Your Honor, because it was unreasonable and part of the arbitrariness that goes to the abuse of discretion. Mainly because the trial court also discounted the entire GAL recommendation. And the GAL recommendation, who had been with these children since 2017. So the GAL had been with these children for 5 years.
The counsel, the judge indicated in the order why he was discounting the GAL's recommendations, since the GAL had not really even, been that involved in the case, had not done the visitations, had not seen them except maybe one time together. There are a lot of factors that the court mentioned as to why the GAL's recommendation should not be given any credence.
Correct. The trial court did make those findings. And again, Melissa's position is that it was unreasonable to make those findings, and it was the abuse of that discretion.
Let me ask you this, I'm sorry,
That's okay.
this is to me important. So did the trial court, or do you dispute, because I don't know that it's necessarily in your brief, that those findings that the trial court made regarding the GAL and their investigation were incorrect?
I believe that in the brief we indicated that the trial court abused its discretion by discounting the entirety of the GAL.
But you don't specifically attack the findings?
Correct, because of the GAL's testimony and the in-depth of the case. So again, the GAL did have...
In the 2012 case you cited, did some of the children in that case not want to have overnight visitation with the mother who had, as you say, kind of taken care of all of her issues?
There were some issues in that case where there was an instance where some of the children did express an interest of not being with mother. In fact, the trial court, at least in that case, the mother proved to the court through various different counseling, and I believe there was an expert witness which this court had discussed within that case that said she has not had any inappropriate conduct or anything of that nature, and there's no issues. And that was one of the reasons that this court found that it may have been an abuse of discretion in that matter to increase mother's visitation. So does that answer the question?
Does that answer the question?
Okay. So as far as Melissa's concerns here are, again, the alienation, again, of also the tortured procedural history of this case, where every single time we were set for trial, there would be an unsubstantiated allegation, and this court can take that into consideration because there were two counties at play, both Trumbull County Children's Services and Summit County Children's Services. At the trial, there was no testimony that substantiated any of the claims by either of the agencies. In addition, one of the things that legal custodian was doing was placing requirements on Melissa's visitation. In fact, in the transcript, under the legal custodian's uncontroverted testimony, the legal custodian, in essence, wanted her to confess to a felony prior to having any visitation with her mother, with the children. So that is something how the trial court did abuse its discretion, and that needs to be noted. And again, as far as Melissa's past was concerned, the uncontroversial testimony demonstrated, and the GAL did too, she was being regularly drug tested. She was on probation at the Summit County Adult Probation Department. She had testified to that. She had testified that she was submitting regularly negative drug screens and all those information, and the trial court did not instead look at that and said, well, so what? There's still a concern. Even though the uncontroverted testimony was that Melissa had alleviated those concerns. And that's, as far as Melissa is concerned, the trial court did abuse its discretion as far as denying her motion for increased visitation, despite even the GAL's recommendation and the ability for Melissa to engage in therapeutic counseling with the children. The court could have ordered that. It did not order that. The court just wholesale denied Melissa's motions. And so, again, with the tortured history of the procedural of how many times the case was set for trial, how many times the continuances were granted, even though we were in a COVID universe, it seemed that every time we were set for trial and witnesses were subpoenaed, there were new unsubstantiated allegations.
You raised the issue of therapeutic counseling. Was that requested below?
It was. One of the things in the transcripts has indicated that Melissa asked the court to fashion a remedy to, in essence, have a step-down order, where perhaps she engages in therapeutic counseling, supervision for a period of time, and then steps down to unsupervised visitation, and then overnights. At the trial court below, every attorney for each of the children, all four of them, attorney for legal custodian, attorney for dad, and Melissa, all submitted proposed visitation orders. So there were 7 proposed visitation orders, which were in the transcript, in the record and whatnot, for the court to consider. So the court did have the opportunity to consider that, but did not ultimately accept those findings.
And I don't recall the trial court's order. Did it make any specific commentary about why it was not ordering therapeutic visitation?
No, the explicitness of the journal entry from the trial court was to deny Melissa's motions for visitation and the increase, and also went so far as to deny Melissa access to the children's records.
And counsel, I just want to let you know you're moving into your rebuttal.
And if the panel does not have any other questions at this time, I will reserve the balance for rebuttal.
Very well.
Thank you.
Good afternoon, Your Honors. Attorney Eddie Siplin on behalf of the appellee, Rhonda Gallagher. And I know that the court has had a chance to read our briefs, but I will just, in summary, just get to the point. Essentially, what the appellate is asking this court to do is to substitute the judgment of the trial court, who sat through a 2-day trial, April 20th and April 27th, and made its finding. And in reviewing the judge's, and I'm sorry, my mouth got dry and the tongue got stuck in it. But in reviewing the trial court's decision, when I look at the arguments made today, it just really comes down to they're saying, we don't like what's going on, and I think that there's been somewhat of a misrepresentation of some of the facts in this matter. This has been a case, one of vexation, what I would term as vexatious litigation. No matter what the juvenile court decided, these parents were going to refile and continue to refile. How do we know that? We look at the record. When Ms. Gallagher was originally given legal custody of the children, they appealed. This court held that there was no change of circumstances, and shortly after there was another case filed, and rather than going through procedural, they chose to appeal. But having said that, I want to address the points that was raised in here that was argued. When the trial court made its decision, he found that, one, the allegations for the motion to modify legal custody, one, he found that the testimony of the parents was not credible. He sat through the trial, he did his analysis, and in fact, he assessed the parents pretended not to understand why the children were not returned to them, avoid talking about their past arrests, convictions, and incarcerations, and they discounted the children's problem caused by their poor parenting and stormy marriage. The parents used the children in an attempt to manufacture evidence against Ms. Gallagher by asking the children to record Ms. Gallagher's private conversations. And essentially, those were part of the reasons why the judge did not find the parents credible. Now, when counsel makes the argument that the trial judge discounted or disbelieved what the guardian ad litem indicated, in his, and I'm not sure if it's an error or not, but it indicated that and gave the impression that since 2017, it was the same guardian ad litem involved in this matter. That's not the case. The original guardian ad litem in this matter was attorney Pamela Hawkins. when the case was decided on appeal and finally decided in 2017, the matter, Ms. Hawkins was no longer the guardian ad litem, and a subsequent guardian ad litem was appointed. And the primary reason that the judge did not follow the recommendations of the guardian ad litem is that during the pendency of this case, he found that the guardian ad litem had visited with the parents and the children 2 times. And of those 2 times, there were no unannounced visits as to what's going on. And so the trial court gave its reasoning, and I won't go through those. The court is aware of the court's journal entry. But what we would respectfully argue is that when the court made the decision not to grant Ms. Tomasick's motion to modify her visitation, the court met the legal requirement. The court clearly stated that it analyzed under the best interest standards under 3109.051D, that it considered those factors under that revised code. And once again, at the risk of repeating myself, it's indicated that the GAL observed 1 visit at the mother's home in December of 2021. He did not observe any visits in the father's home until April of 2020. He was not aware of the parent support orders. He had observed only mother and father's interaction only once. He never made any unannounced visits, and he being the guardian ad litem was unable to make any specific recommendations as to the extent, duration, conditions of the parents' visits if the current order was modified. The court found under the best interest standard that the current schedule that was in place promoted the best interests of BT, the 2 BTs, because I was almost called the name, but the 2 BTs, and in regards to AT and LTs, it was best to have their visitation schedule changed. And what the court ordered was that mother was to continue to have supervised visitation with BT, the BTs, every Saturday for 8 hours during father's weekend visitation. AT could visit with the mother only if the child agreed to do so, and he put limitations as to who could supervise those visitations, and indicated because there were allegations that the father was supervising the mother's visitation. The court specifically stated that the father could not supervise the mother's visitation because of issues of father discounting mother's behavior. And part of what the court went in, because there were some allegations that mother was sexually inappropriate with the children or inappropriately touching them, put on the guidelines that the mother cannot transport the children by herself because she didn't have a valid driver's license. And more importantly, she said that the mother may not bathe the children or put them in the shower during her visitations, and mother may not remove the children's clothing. And under no circumstances should the children have overnight visitation with the mother because of the nature of the allegations. Now, appellate counsel would give the impression that the unsubstantiated matters involving the children were at the behest of Ms. Gallagher, and we would vehemently disagree. The situation with the suicide of one of the young girls, Ms. Gallagher's primary focus was getting help for her granddaughter, and when appropriately, she contacted the father and let him know. And as the court noted, because of the contemptuous relationship between Ms. Gallagher and Ms. Tomasick, they didn't talk to each other, and they, you know, she did not purposely exclude mother from it, but as a result of that, the child indicated that she wanted no contact with the mother, and that's why the court fashioned it there. Ms. Gallagher has been the saving grace of these children. In the motion, Ms. Tomasic alleged that the children were malnourished, not being fed, and quite to the contrary, during the pandemic, the kids became overweight. But more importantly, Ms. Gallagher has been the person that has put the kids as the paramount priority for her. She's been the person making sure that they got to, for 4 kids, getting to all of the counseling appointments, getting to doctor's appointments, getting to all academic activities and sports activities. And the information that was presented in court is that the children thrived under Ms. Gallagher's legal custody, and that there was no change of circumstances. But with regards to mother's request, the court found that it was not in the children's best interest that be granted, and that there was no change in circumstances.
Was the issue of therapeutic visits brought up at the hearing, and was that request made to the judge?
And what it came down to, the judge deferred that to the counselors. If the counselors felt it was appropriate, then it would.
The counselors of the children?
Of the counselor of the children. And from my standpoint, and what Ms. Gallagher indicated, that whatever is best for the children, and if the counselors recommended it, she would not object.
Is that clear in the order?
It is not mentioned in the court's order, but I do know that that did come up during the pendency of this matter. And Ms. Gallagher has been the one that has tried to maintain the relationships between the children and their parents. However, it's been Melissa Tomasic who would try to do gamesmanship. There was testimony presented at trial where she had told the children how to create an issue. There was, that's part, and I thought I turned my phone off, but I forgot to turn my watch off. That there was testimony that, and evidence presented from appellate counsel where mother is talking with the child, telling the child how to run away, how to make it so that they can create a matter to come back to court. And the court considered all of this. The court was there to assess the credibility of everyone and had the facts there, and the court fashioned a decision that was in the best interest of the children, and parcel for their continuing modus operandi. We knew that this matter was going to be appealed in some way, shape, form, or fashion, in spite of the judge writing a very clear order as to why he was finding the way he was. And with that, I would rest.
Thank you very much, counsel. Attorney Buchanan, you'll have 4 minutes and 44 seconds for rebuttal.
Thank you, Your Honors. May it please the court. I'd indicate that the panel had a question in regards to the therapeutic counseling. Melissa's position would be, how can she engage in therapeutic counseling when she's not allowed any access to records and the legal custodian never communicates with her? And that's in the order. So the court would be asking for an impossibility. That's part of the unreasonableness and arbitrariness, which leads to the abuse of discretion. So as far as Melissa is concerned, again, under 2151.011 B50, that, as this court knows, it defines residual parental rights. It's not an exhaustive list, and the ability to have knowledge and have communication with each other, in addition to what is going on with the children's lives. One of the proposals made included using a application where the parties could, like talking parents and other methods that will allow people to communicate with each other and share that kind of information. In addition, the trial court did find explicitly in this order that the custodian and Melissa do not communicate directly. So to indicate for the court's perspective, how does a mother with residual parental rights try to engage in any therapeutic process or any process if there's no communication directly?
Counsel, I just want to make sure I'm clear on something. The original motion was for unsupervised visitation.
Correct.
Okay, and then the mother did add the motion for change of legal custody.
Correct.
Okay, so the court found that there could not be any change of legal custody because there was no change of circumstances.
Correct.
So we're not really disputing that. You seem to be appealing just on the visitation issues.
Correct. Correct. Yeah. Melissa is appealing not the legal custodian motion. It's the motion denying outright her motion to change the visitation for increased visitation. And that's what brings us to the abuse of discretion standard. However, if the trial court did make an error of law in interpreting the statute, this court is permitted to de novo review. And as far as, in addition, legal custodian under 3109051 D10, the legal custodian has to be willing to reschedule time. And again, how does one reschedule time or make accommodations if they don't communicate? Therein lies the issues. As far as Melissa is concerned, she is asking this court to find that the trial court abused its discretion by denying her motion outright and instruct the court below to fashion a remedy that would permit visitation by Melissa with her children in such a fashion to promote her being involved with their lives, as this court has plenty of case law indicating that children need both parents. And with, if the panel does not have any other further questions, Melissa would thank the court for its time and appreciate it.
Any questions? Hearing none, thank you very much, counsel. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. Court reports will mail a copy of the decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website.